Thank you so much, Meg, and thank you and Lisa for inviting me to speak to the group today. I look forward to our discussion during or after the presentation. So let me go ahead and share the screen. So, as you know, during COVID, courts had to close for public health reasons, and in order to continue processing cases without unreasonable delay, a number of them across the country began using a virtual format. So you had everything from grand juries to bench, and in Texas, even a misdemeanor jury trial, to sentencing hearings and probation revocation and parole revocation hearings happening on digital platforms remotely. Now, most state courts and the federal system already permitted some limited use of video conferencing for at least some criminal proceedings, most commonly for initial appearances and arraignments and bail hearings. And in most cases, that required the consent of the defendant, but some permitted it even without the defendant's consent. And again, that was typically limited to initial appearances, arraignments, and sometimes bail hearings. Sometimes more than that, but those are the most common ones. Now, during COVID, Supreme Courts issued emergency orders across the country, state Supreme Courts, and many of those expanded the use of remote criminal proceedings to more types of proceedings, as I mentioned earlier, in some cases starting with grand juries, and in some cases, reaching all the way to bench trials and even jury trials. And the other thing that happened is that more proceedings were permitted without the defendant's consent. So that was another change as a result of COVID. And this was justified on the grounds that it was necessary to protect public health and also to permit, again, the speedy resolution of cases. So complying with speedy trial rights. So there are a number of constitutional rights that are at issue in remote criminal proceedings. So the right to be present, of course, which many courts interpret as physically present. So the right to be physically present, which is part of the due process right. The right to counsel, can be affected by the remote format. The right to confront witnesses at trial, the right to a public trial, and if we're talking about juries, then the right to a fair and impartial jury may also be affected. And then, of course, we have the right to a speedy trial. And as I mentioned earlier, that has actually been given as a justification for having the virtual format. So some, that's seen in some of the emergency orders, but also in some of the case law that has discussed virtual hearings during the pandemic. So I want to mention just a few. I won't have time to cover all the ways in which courts have addressed these constitutional rights. We can cover more in Q&A, but just a couple I wanted to highlight. Some of the case law coming out from the pandemic. So there was already case law on video conferencing before the pandemic and how it affects due process rights or confrontation rights, how the virtual format impacts those rights. But in the context of the pandemic, states have been arguing that, well, it's different now. The state interest is stronger because we're trying to protect public health as well as, again, protect the right to a speedy trial. So even if some of these rights are impacted, you should take that into account. It has to be balanced against the state interest in protecting public health and promoting the right to speedy trial. So, so courts have addressed the right to be physically present in three contexts: suppression hearings, Daubert hearings, and probation revocation hearings. Suppression hearings, there have been several cases, and in some of the jurisdictions, the right to be present is not actually firmly established at a suppression hearing. So the court is, would reason, well, it's not clear whether the defendant actually has the right to be physically present at a suppression hearing. But even if the defendant did have a right to be present, due process was nonetheless met because these are the various steps that the judge took to ensure that the hearing was fair, even though it was virtual. And furthermore, the state has these important interests in protecting public health and again, protecting rights to speedy trial. So in one case out of Massachusetts, the case law is actually very clear that the defendant does have a right to be physically present. And even so, the court there found that even though it was clear that the defendant had a right to be present, again, the virtual format during the pandemic complied with due process guarantees. Again, in part because of the guarantees that the court, the procedural safeguards that the court took to ensure that the hearing was fair, but also, again, the state's interest in protecting public health. Somebody asked about citations for these cases. I can send those to you after the talk. If you just email me, my email is jenia@smu.edu. So just email me and I can send you those cases. Some of them are in the paper, which is available on SSRN, but some of them are newer, so they're not included in the paper. But I can send you the citations for those that are not in the paper. Okay, so Daubert hearings, again, that was a federal case where the court said, well, it's not clear that the defendant has the right to a physical presence, but even if the defendant did have that right, again, balancing the interests and taking into account the safeguards that the court took, it complied with due process. Probation revocation, there's an appeals court from Florida, which said this complied with due process, in part because probation revocation, the due process analysis is different because it's not a criminal proceeding, so the safeguards don't have to be quite as strong as they are in a criminal proceedings. And again, the court emphasized the stronger state interests during the pandemic. Now, an interesting question is, what about plea and sentencing hearing? The right to be physically present is generally more firmly established at those hearings. And of course, they have been happening all over the country virtually, and in many cases without the defendant's consent. Certainly emergency orders in many states permit for them to happen without the defendant's consent. So does that comply with due process? Because if you look at the pre-COVID case law, in terms of statutes and case law, yes, there were some statutes that permitted plea hearings without the defendant's consent, but most state statutes require the defendant's consent, and there's case law suggesting, again, the cases are not unanimous, but case law suggesting that the due process clause requires physical presence unless the defendant makes a voluntary and informed waiver. So I'll come back to that question in the next slide. But just to give you a sense of what about the confrontation rights, courts are split on that one during the pandemic. So we have two courts that have held no virtual testimony was permitted because reasonable alternatives existed where the witness's health and public health would still be protected, and they didn't need to testify remotely. They could still testify in person. So one was a case out of Montana where the witness had to travel from Wisconsin, and the court basically said the witness could travel by car and avoid air travel. And in another case out of Kansas, the court said it was an expert witness. So the court said, well, the prosecution can find a witness from the area. This witness had to travel from another state, or the court can continue the trial. So the court said there are other reasonable alternatives, so it wasn't necessary to protect the health of the witness or public health But there are 3 other cases, one out of the Virgin Islands and a couple out of federal district courts, where witnesses had to travel long distances, and the courts decided that in some of those cases, the witnesses were elderly or high risk and medically vulnerable, that is, to COVID, and the courts decided that virtual testimony was necessary to protect the health of the witness. And under Maryland versus Craig, it used this balancing test, which, as I discussed in the paper, there's some case law that questions whether Maryland versus Craig can be extended to adult witnesses or whether it should be kept only for purposes of child witnesses who are testifying. But in any event, it seems that most of the lower courts read Maryland versus Craig to apply to adult witnesses and video testimony of adult witnesses. And they've been using this balancing test and trying to figure out if the remote testimony is necessary to protect an important overriding state interest. Okay, so I mentioned earlier, what about plea hearings? So part of, so this presentation is based on a couple of projects. One project was a survey of Texas practitioners and judges over the summer about their views on remote proceedings. And the other project was actually observing mostly plea hearings, so close to 300 virtual plea hearings in Texas and in Michigan. Both of those states live stream their most of their criminal proceedings, or many of their criminal proceedings. I actually still don't know if it's most or many, but certainly many of their criminal proceedings are live streamed. And so my RAs and I watched close to 300 virtual plea hearings over the fall, basically starting at the end of August through early February. And we observed various things, but a few that I wanted to focus on here. We were wondering if at the plea hearing, the court actually obtains the defendant's consent to the virtual format. And we found that only in about a third of the cases, even a little bit less in Michigan, do courts do so. Now, we did not see the paperwork filed in the case, so it's possible that it's a it's a larger percentage where there was paperwork where the defendant actually waives the right to be physically present and consents to the virtual format. But as you know, typically courts will bring up, if there's a waiver, they will actually bring it up at the plea hearing, even though it's also in the paperwork. So when they're talking about the various other waivers of constitutional rights that are part of a guilty plea, even though there's paperwork where the defendant is has signed off on waiving these rights, these trial rights, the court still brings that up at the hearing. And in fact, in the hearings that we did observe where the court did bring up, did ask the defendant, do you consent? Many times there was a written waiver as well, but they would ask, so do you consent to the virtual format? And sometimes they would hold up the waiver. So again, it's a small minority. Neither the Michigan nor the Texas Supreme Court emergency orders require the consent of the defendant to a remote plea hearing during the pandemic. Now, as far as pre-pandemic law goes, in Texas, to have a video conference plea hearing, the consent of the defendant was required. In Michigan, it wasn't. So pre-pandemic, the consent wasn't required in Michigan, and it's not required in the Supreme Court emergency order. In Texas, the law is different pre and post and during pandemic. And again, perhaps because the Supreme Court emergency orders don't require it, we see that it's rarely obtained from the courts. Also, we were curious whether the courts mentioned to the defendants. Again, that's not something that's required under the law, but I think it's good practice to ensure that the right to counsel is observed in these remote hearings. we were wondering if courts ever mentioned to the defendants specifically that they have the right to consult counsel privately during remote hearings, because that's often an issue, something that came up in the survey actually. You can set up a breakout room, but of course the defendant needs to know that that's an option, and perhaps counsel mentioned it, but whether the defendant remembers, it's not clear, and whether counsel mentioned it is also not clear. So we were wondering how often the courts bring it up, and not very often, as you can see, in only 3 to 5% of cases. And then we also kept track of technological problems or disruptions, and again, that's in the fall of 2020, so courts had some time to kind of iron things out with Zoom or whatever platforms they were using. And in Texas, we found technological problems in only 8% of the cases we observed. In Michigan, it was higher, it was 18%. And they varied from things like someone couldn't hear well or part of the proceedings, or they couldn't see well, or someone dropped off the meeting at some point. So they varied a lot. We also observed, I could talk about that in Q&A, it's not in my slides, but we also observed the informality of the remote settings, so defendants appearing from all kinds of different settings, even attorneys, like we saw one attorney driving while she was appearing at a plea hearing. So kind of a wide variety of settings, which we can also discuss again in Q&A how that affects the hearing. Okay, so one question that drove my research is there seems to be some evidence, and in fact, there's now a bill introduced in the Texas legislature, and I'm sure that's going to happen elsewhere, that what we're seeing in the pandemic is going to hold to some degree the use of the remote criminal proceedings. So as I said, the Texas legislature already, there's a bill to expand the use of remote criminal proceedings. And based on the survey that I did in the summer and just reading the newspapers, I can tell that a lot of people are, a lot of court administrators are excited about this, and prosecutors are excited about the prospect of continuing with remote criminal proceedings after the pandemic is over. So I thought it was important to figure out what are the advantages and disadvantages of these remote proceedings, and should they be continued after the pandemic? And also, as far as the constitutional questions go, the due process balancing also considers these, costs and benefits on the various sides. What are the state interests? What are the benefits for the states and for the defendant? And what are the costs of the defendant's constitutional rights? So there's some prior research on video conferencing. As I mentioned before, it's been used in states even before the pandemic. It's been used in other countries. England has been using remote proceedings quite extensively even before the pandemic. Australia, there's several common law countries have used them before. So what prior research shows is that the main advantages seem to be, and the research is not monolithic on this, by the way. There's research that kind of shows different things, but that generally they tend to save time and resources for the participants and for the criminal justice system. And before COVID, that was mainly because it mainly concerned detained defendants. That's when it was used the most. A lot of the costs saved were in transporting the detainees to the courtroom. As we'll see with the pandemic, the costs and benefits are somewhat different because there are savings also to defendants who are not detained. Okay, so then reduce costs and improve safety, again, in the transportation of detained defendants. As I mentioned, that was mostly how it was being used, and expediting the processing of cases. So there were some findings that, at least in some settings, it tends to expedite the processing of cases. Again, it's not the findings are not uniform, but that tends to be kind of what most studies have found, or at least that's what most people perceive to be the case. There's only a couple of studies that actually studied where they, from England, whether it shortened, whether it in fact saved time, and one of them found that it didn't. So, but the perception is that it expedites the proceedings for sure. Okay, so what about disadvantages? The prior research found that it can impair adequate defense representation because of difficulties communicating confidentially during the video hearings, and also depending on whether counsel and defendant can meet in person or not before the hearing. That could also impair preparation for the hearing. Tech glitches can prevent the defense from participating fully, and that could be the defendant or it could be defense counsel. One finding that came both from the immigration context and from the criminal context, and again, this comes from England where this has been studied more empirically, that defendants can disengage from the process and be less likely to seek legal advice, which then may be the reason why in some cases there are worse outcomes in remote hearings than in in-person hearings. In fact, there's a very good empirical study in the immigration context by Ingrid Eagley, who found that there were worse outcomes, but she tracked it to the fact that defendants disengaged from the process. So they didn't seek legal advice, they were less likely to pursue certain claims. So that was the reason for the worse outcomes, not because remote proceedings as such had a lower rate of success for defendants, but simply that they never pursued some of these claims or never got legal advice. So another concern from prior research is that poor lighting, image, or sound quality can prejudice perceptions by the court, of the defendant or of witnesses. There's some social science suggesting that that can happen. And then that the video as a result makes it difficult to confront witnesses. Also that it makes it difficult to police witness misconduct because, you can't see if the witnesses being coached, for example, or is otherwise, that's the main concern about misconduct. Okay, so a little bit about the study that I conducted this summer. It was a web-based confidential survey that took about 10 minutes for the participants, or a little more if they wanted to write longer comments. And it was with Texas practitioners and judges. Over 500 participated, and they were mostly state, but as you can see, there were some who were practiced exclusively at the federal level. They're in the parentheses. And we got a pretty good representation of Texas counties, so rural, suburban, and urban. And I wanted to just highlight some of the findings. More detail is available in the paper, but some of what we found is that a large majority of the respondents believe that the remote proceedings do in fact save time or expenses for time or resources for defendants, defense attorneys, prosecutors, and the court. Now, there were significant differences in some of these responses between what the defense attorney responses were versus, let's say, the prosecutors or the judges. But even though the defense attorneys generally were less likely to believe that the remote proceedings save time or resources, nonetheless, a majority of them believe that to be true, sometimes, often, or always. We also asked about, whether the respondents believe that remote proceedings help resolve cases more expeditiously. And as you can see, it's still a majority of respondents who believe that to be the case, although it's a smaller majority. And there was a significant minority that actually thought it wasn't more expeditious, or perhaps it was more expeditious for some, but it was more burdensome for others. So for example, the defense attorneys would often say, well, I actually ended up bearing more of the paperwork burden because I had to figure out how to get my client's fingerprints or his signature. So it wasn't, in fact, more expeditious for me, even if maybe in the end it helped resolve the case more expeditiously from the court's perspective. Or, you know, yes, maybe it helps resolve some cases more expeditiously. On the other hand, some respondents said it's harder to plea bargain because we can't see people in the courtroom. So it takes a little bit more time to get pleas that otherwise would have been resolved in the hallway. So just a few select quotes kind of that explain why people thought it saved time and resources. So prosecutors found it very helpful with out-of-town witnesses, that it helped cut down on travel and costs and made it more convenient for witnesses to appear. Both judges and defense attorneys talked about how by cutting down on travel, particularly in rural areas, it was very helpful because sometimes attorneys, you know, would have to travel on the same day, you know, hundreds of miles in order to get to their next appearance. So this helps by cutting down travel. And again, it saves times and resources for the courts. So talks about how it makes appearance by jail defendants easier to facilitate. Again, the cutting on transportation time for attorneys. And then this is from a judge who said, makes it much easier for us to schedule hearings because we can get a reporter scheduled much quicker and easier since they aren't having to travel an hour plus to get to us. And again, this is from a rural court. This was from a defense attorney who talked about how remote hearings can save time and resources for defendants, how having to appear can actually be punishment for defendants if they have to appear for status hearings on a monthly basis. And in fact, there is some evidence already that failure to appear rates have gone down during the pandemic because of the remote hearings. So, and this was shared by some of the respondents. And then how it can save time and resources for attorneys. This defense attorney said, well, too many times we sit in court waiting for the plea, but with remote hearings, if the plea is done virtually, I can just do it at my desk and multitask essentially. And then most respondents also agreed that remote proceedings provide broader public access. Again, this was in Texas, and in Texas, state courts live stream their proceedings. But we did find a significant difference between state and federal respondents, which makes sense because federal courts did not live stream. And in order to get access to a federal court proceeding, you had to actually get the link from the court. So it wasn't just available to the public at large. So their public access was actually hindered, whereas with respect to the state proceedings, when they were live streamed, they were in some ways broadening public access. Of course, it requires technology and it requires the know-how to figure out how to access these proceedings. But in some ways, they broadened public access in the sense that you didn't have to travel to the courthouse to watch the proceeding. Okay, so some of the disadvantages that the respondents mentioned. Paperwork challenges were the #1 disadvantage mentioned. So how defense attorneys especially talked about how difficult it was to prepare the relevant paperwork, especially getting signatures during, if you try to get digital signatures or digital fingerprints, that was, or just getting fingerprints was a challenge for them. This has gotten better over time. So again, this survey was in the summer. I think in many situations, courts have adopted their processes, and there's, for example, digital fingerprint kiosk in the Dallas County Jail now. So there are various ways in which that has gotten better, but at the beginning in the summer, courts were not uniform in how they handled this, and defense attorneys in particular really experienced it as a significant burden. And then this one was not surprising given what the prior research had said about challenges with evaluating witness credibility. There was a broad agreement among both prosecutors and defense attorneys that a major disadvantage of these remote proceedings is that it's difficult for the parties to assess and challenge witness accounts or credibility, and likewise difficult to present the case effectively. We did not ask prosecutors this question because we didn't think they would necessarily have an insight into it, but judges and defense attorney respondents also agreed with this being a common, sometimes, often, or always true that it interferes with attorney-client confidentiality. Again, this has to do with the difficulties of clients and defendants being able to communicate during a remote proceeding. A smaller majority thought also remote proceedings created difficulties for indigent defendants to access the technology necessary to take part in online proceedings. And here's a major difference between the defense and judges and prosecutors. Defense attorney respondents overwhelmingly thought that the remote format favored the prosecution. So 71, almost 72% thought that to be the case, whereas the overwhelming majority of prosecutors and judges thought that there was no noticeable difference between in-person and remote proceedings, which explains also the next slide, why there's a difference in the next slides. We also asked whether the respondents would like to see video conference proceedings used more frequently after the pandemic. And as you can see, there's a difference between the groups. So among defense respondents, 48% said yes. So, a minority of respondents. By contrast, prosecution and judges, 70% of prosecutors said yes, 60% of judges. And there was an opportunity to comment, and you could tell that, a lot of the respondents said, well, I'd like to see them for certain types of proceedings, but not others. So they would say maybe for status hearings or certain non-adversarial hearings, but not others. Or they would say definitely not for jury trials, but maybe for other proceedings. So, that came out in the comments. It doesn't come out in this question about whether they would be in favor or not. So just keep that in mind, that maybe they're just talking about certain types of hearings that they want to see continued after the pandemic is over. So this is a prosecutor who thinks that it would be helpful to have it for witness testimony. A defense attorney in the blue bubble talking about how it would be helpful to have it for consultations, to have consultations more frequently with clients who are detained. And another respondent saying that it can improve public access if hearings are live streamed. And here are some concerns about confrontation of witnesses or having a jury trial being held remotely, why that would not be a good idea. And then just more generally that, that zealous representation cannot be had in a remote format is what this person thought. And also that how the public perceives it is different, that the legitimacy in the public's eyes can be lower. And likewise, the defendants may feel cheated by the justice system if we continue to have virtual hearings. And this is kind of sums up a lot of the defense concerns that remote hearings can feel dehumanizing for defendants. So my conclusion after, watching these hearings and doing the survey and reading kind of scholarship on video conference hearings before the pandemic is that these should be used, we should be very cautious about expanding the use of remote proceedings. I can see them being used for status hearings or hearings on questions of law. I can see them being used perhaps for lawyer-client consultations to increase the availability and frequency of such consultations. But beyond that, I think, at least for the moment, they carry too many risks to be used with regularity. And in the paper, I have some suggestions about if they are used, what can be done to make them fairer. But again, I think beyond the pandemic, they should be used sparingly. So I'll stop here and be glad to answer your questions or hear about your experiences or impressions of remote criminal proceedings.
Thank you. And we already have quite a fair amount of questions, so I'll just start there and see how it goes. So is anyone tracking the source, or anybody or source tracking this legislation to regularize or expand remote proceedings around the country? Do you know any?
I imagine that the National Center for State Courts might be. I will be tracking some of it. I can't say that I'll have a comprehensive list, but I am interested in tracking it myself. So who is the person who asked this? Oh, Rebecca Schaefer. Yeah. Oh, hi, Rebecca. I can, as I do that, I'm working on that at the moment. I know Texas, as I said, has legislation. I would think that either the National Center of State Courts or maybe the, what is it, the NCSL, the state legislatures, is it the National Center for State Legislatures or something like that? They may have one. I can try to follow up with you on that.
Okay, thanks.
Sure.
And then Rebecca also had a comment or a question about, you did talk a little bit about bench warrants for failure to appear plummeting. And yes. Jenia, I know you had said you had seen that also.
Yes, there's some early evidence, from several jurisdictions where that seems to be the case. Yes.
So I wonder though, I know there's been discussion of how easy it is to give out warrants to bond forfeit people right now because of COVID. And so there might also be some of that going on where people aren't bond forfeiting as quickly because of COVID, because you can't.
That's interesting.
It's been, well, I mean, I don't know, like I'm not always involved in all the conversations. I know in Travis County, there were conversations at some point very early in the pandemic about what it meant to give someone notice, since we were just rescheduling things like rapidly, and sort of what notice did the defendant have to have before you could bond forfeit them at that point. I know things have changed since then. And so I haven't been involved in those conversations since then, but it's something to at least think about.
Okay. Yeah, it's a interesting point. Yeah.
Yeah. So Michael Merzinski have asked, there are related concerns predating COVID about how video proceedings can more easily dehumanize, and I think a few questions about that, accused individuals.
Yes, so there have been some studies about the effect of technology, different camera angles, can you see the whole body? So there's one study that shows that this is with respect to witnesses, but of course it would apply with respect to anyone, that if you see the whole body, you can see the body language, the witness is more likely to be found credible. There's other studies showing how camera angles can affect perceptions, lighting, and of course, if you're appearing from the detention center, there's very little you can do to control that, but it's a question of, okay, have we instituted protocols in the detention center about how defendants are appearing? And I should say, from the hearings that we observed, actually the main problems we saw with, this is not a social science, I can't claim to be able to assess the effects of camera angles or lighting, but just from a lay perspective, what we saw that from a lay perspective concerns me the most were actually the people appearing from home on their phone, because usually defendants appearing from home or elsewhere were appearing on their phone, and as you can imagine, a lot of times the camera angle was not good. There were multiple times when the defendant, you couldn't even see their whole head, or there were just weird angles. We observed, so out of 300 hearings, there were at least 8 hearings where the defendant was not seen at all. So they were appearing via phone, but you could not see them. So I think they had just connected via their phones. So actually I'm more troubled by those situations where they're appearing from a really, from a setting where it's bad lighting. Oftentimes there's distractions in the background because they're appearing from home during the pandemic. There was a defendant who appeared from a construction site because he was a construction worker. So yeah.
I mean, there are a few comments here about those. So Marty Crawford says she thinks there's some studies about camera angle, et cetera, effect in police interrogation videos that are interesting. Richard Pittman says, my good friend, the late, great Rob Mason, talked about a caste system in virtual hearings. At the top are people with good technology, who are, with good technology, camera, microphones, and strong Wi-Fi. In the middle are people with technology, but who are not very comfortable using it, and the people who have no choice but to call into Zoom by phone and have no access. I actually am not, was that written somewhere, or? Yeah, that's in the Richard Pittman wrote that in the chat. I don't know if, do you know if Rob Mason wrote anything about that caste system, Richard?
I believe he gave an interview to a reporter where he said something similar to that before he passed away. I could probably find that link. And he said it in a training that he gave for our juvenile defenders here in Louisiana. Okay. Yeah, I think that's an important observation, because I do think there are different things, right? There's the technology, there's the connection, and then there's the know-how to use the technology. So that's right. It's a good observation.
And then Malia Brink asked, or made a comment, then asked about the right to have friends and family attend is slightly different than the right of the public access, and is one thing that can help humanize defendants. Live streaming, if it is also meant for family and friends, does not accomplish this. But then she also, do you track or ask anything about access for family and friends in your studies? Yes,
so in the sense of, can the family and friends observe the proceedings online? Just if it's live streamed, anyone can attend. Now, if it's in the sense of watching it online, right? So it doesn't matter whether it's a friend or family or members of the public. For, again, in federal court, you have to actually request, and that's true in many states as well, probably most states, you have to request a link to the hearing. So it's not available to the public at large, but yes, members of the family could request the link, members of the media can request the link, etc. I don't think there are limits on who can attend, but you have to request it. Now, one thing that has happened with remote hearings is because they happen from home, we did observe some defendants with their family members next to them at home, which can actually be very comforting. In some situations, we had a defendant who, was crying, but her boyfriend was sitting right next to her, and that probably helped her, having him right next to her. Now, in some situations, the judges didn't like it when family members were present, and so when they saw that someone else is present, they asked them to leave the room. So I'm not sure why that had to be done, given that it was a plea hearing. So it's not like there was anything confidential happening, but we did observe one hearing where the judge did ask a family member to leave the room. So I think in general, judges, we saw a number of hearings where a parent was present or a significant other was present. So that was not a problem if they were appearing from home. And again, if they're live streaming, people can see them from anywhere.
As Malia points out, though, that there's a difference between people being able to see it and then that the defendant can see the people. So like having family and friends to support you as a defendant, and also that the judge can see them and knows that you have those family and friends.
That's right. So that is one thing. So even if they're present at home, you know, is that the same as can the judge see them? I agree. That is an important point, that having the support of the family in the courtroom is important, both for the defendant and for the judge's perception. That's a good point.
Yeah. And then Maria Beeman asked if you, she joined late, was there an effort to get client perspectives on virtual proceedings?
Yeah, so I don't think I could have done that with, you know, the IRB that you need to get. And during the pandemic, that would have been very difficult to do. However, there is a book, it's not from the US, it's from Australia, but there's a book by Carolyn McKay that examines the perspectives of detainees and prisoners who are appearing in virtual hearings. And I found that very useful. Again, it's in pre-COVID context, and it's only with respect to detainees or prisoners. But it was very interesting because a lot of the same concerns that have been expressed in other literature come up with defendants who are appearing in virtual hearings. Now, some of them really liked it. It wasn't, again, it wasn't a uniform view, but many of them did express a concern that the hearings weren't as fair, or they just wanted to see the judge in person. And, you know, there were certainly the majority expressed concerns, but there were a number of prisoners who liked not having to go to court and appearing virtually. So,
Gary Perlmutter, so is sort of a comment, but generally prosecutors, attorneys, and judges know one another from in-person contact. So there's a concern that would be that we no longer that the longer we use remote appearances, the less likely attorneys, prosecutors, and judges are to know one another's communication style. So again, it's sort of that loss of human connection that even though we can all see each other, we're missing some of those other like subtle body language signals.
Yeah, I think that's right. And I think, you know, that again, that came up in some of the comments and how it, in some ways, it makes plea negotiations difficult, or more difficult, in the sense that you don't see each other in a courtroom. And I would imagine especially for, you know, newer defense attorneys, that would be a problem. You know, if you've already established a relationship, but if you're new to the jurisdiction or you're just a new defense attorney, I can imagine that being quite difficult, you know, to manage now remotely.
I see that in my everyday work, right? So people I've known forever, that we've been working together forever, being remote is no different at all in a lot of ways. It's the new people you don't kind of have that same rapport with. It's a different thing. So I think that's very interesting though. Cynthia Alcon, in the hearings you observed, was everyone attending virtually, or were there hearings where some attended virtually and some in the courtroom? For example, the judge and the prosecutor in the courtroom and the defense lawyer and defendant attending virtually. And if there were different formats, what observations did you have about the differences?
So what was the most common, if they weren't all remote, what was the most common configuration would be that the judge would be in the courtroom and then everyone else appearing virtually. There were occasionally, there would be, you know, only the prosecutor and the judge. Even when the prosecutor appeared, it seemed like they were somewhere in the courtroom, or somewhere in the courthouse, but not in the courtroom. I think there was one time or a couple times when we saw that. You know, depending on where we were in the pandemic, so at various points in the fall, I know in Michigan, we observed a few hearings where, yeah, we would have the defense attorney and even the defendant in the courtroom. There were situations, I would say the most common actually, after just being the judge, just the judge being in the courtroom and, you know, the court reporter. The second most common, I believe, was judge and defendant. So sometimes the defendant would be present, but, you know, sitting or standing quite far apart from the judge. But the defense attorney and the prosecutor were remote. And of course, it's a good question because there have been concerns about if the prosecutor is present with the judge but not the attorney, you know, does that give the prosecutor an advantage? And there was a study from Australia pre-COVID that examined these different configurations, an empirical study. And I remember that the one configuration, I can't remember now how they all came out, but the one thing that they emphasized was that it's really important for the defense attorney to be with the client whenever possible, in terms of how it affected the perceptions. You know, it was an empirical study, but so that was important to have the attorney with the client. And again, this was pre-COVID and they were testing different configurations, but I know there's also concern about the prosecutor being with the court, but not the defense attorney. So,
yeah. So Richard, go ahead and unmute yourself. And I'll just, there's some other comments about people being in the room, but go ahead, Richard.
I want to bring up a couple of concerns I have with these recommendations. The first one being that I think your recommendations should be qualified by saying that they should never occur in detention hearings involving children.
okay.
That's just a terrible time to do this. The children need to be able to see and hear. They need to go to court to see their families. You know, in some ways, the inconvenience of transporting children to and from detention is a feature, not a bug. That makes it harder to put kids in detention because they have to then commit these resources to going and getting them and bringing them back. We don't want to make it easy to put kids in detention. Another thing that I think your recommendations need to take account for are people who have disabilities that limit their ability to communicate or understand mediated communication. And part of that's why I think the informed and voluntary consent, it's really easy to coerce people into giving consent and to make it costly not to give that consent. And I think when people hear informed and voluntary consent, like, well, you know, you can have your hearing in person if you want, but you know.
Right, can become a bargaining chip.
Yeah.
Yeah. Yeah, and I think it's especially problematic during COVID, of course, because of, you know, the spread of COVID and detention and the additional pressures that that poses, no question. And again, this is sort of, if courts continue to use these hearings, they should take these safeguards. My preference is for us not to use the remote format other than for status hearings or hearings on pure questions of law. So I'm generally skeptical of the remote format, at least until we learn more. Right now, it doesn't look promising to me. But fair point about children. I had not considered that actually, just because I don't think any of the hearings I observed involved children, and so it wasn't on my radar.
It's hard to get into those.
Point. Yeah, it's a fair point. And on the consent, again, it's only if these hearings are held, then at the very least there should be consent, is what I'm saying. But
well, thank you so much. We are at 1 o'clock now, and I like to be, we like to be cognizant of everyone's time. This was a wonderful talk and a wonderful discussion. We have the chat. We have a lot of, there's some other comments in the chat that I will send you. But thank you so much. And it's been great to hear from you.
Thank you so much. Lots of really useful questions and comments. I appreciate it. And thanks again for the invitation. Good to see some folks I know. So
Yes, and thank you, Lisa, again for bringing us Jenia.
thank you. Bye.